All right. Good morning, everybody. Court will now go in session. This is County Court Law number 4, Judge Fred Garza, July the 8th, 2020 docket. And because we're not in the courtroom and everybody's out in their own office, we're going to YouTube. The first case here is cause number F0459-20-4 and set for 10 o'clock. And it is in the interest of Philippa O'Connor. Did I get that
Yes,
right?
Your Honor.
All right. Good morning, everybody. Put your names on the record, please.
Canales for the
Armand-
respondent, Caleb Betzel.
All
Armando
right.
Guerra on behalf of the petitioner, John O'Connor.
Okay. Mr. Guerra, you represent the, who was it? John
Petitioner.
O'Connor?
Mr. John O'Connor, Judge?
Okay, O'Connor. And
Petitioner?
he's a petitioner. Okay. And Mr. Canales, you represent
The respondent, Judge Caleb Betzel.
respondent Kayla. Okay. There we go. All right, gentlemen, what do we have here?
Judge, I did file a motion for entry of a temporary order that you issued on June 17, 2020. I have sent a copy of the temporary order
Okay.
along with calculation of child support and everything.
All right.
Your Honor granted my client standard visitation with the child, general management conservatorship, the child support that he had to pay, medical support, and supervised visits by his mother, Ms. O'Connor, standard visitation pursuant to the family code. However, and this was done in June 17th, my client has been denied access to the child. They failed to sign the entry of the temporary order. My client has missed Father's Day, Your Honor. Missed Father's Day with his child because it was that weekend, that third weekend after June 17th. And my client's visitation this summer should start, has already started. He's already missed 7 days, 7 days at least since July 1st.
Okay.
And that's the motion that I filed, Judge.
May I respond, Judge?
Yes, sir.
Okay, Judge. So, as Paul Harvey says, the rest of the story. And so
Okay.
the child is 6 months old, Judge.
Uh-huh.
That child is breastfed
Mhm.
5 times a day, skin to skin. My client's here, and I can put her on the stand so she can testify if necessary. We've already turned over those logs. She keeps a very detailed account of when she feeds, burps, etc. The father, in this case, Judge, left the mother when she was 8 months pregnant, and just recently, through this case, has tried to establish a relationship, which we're not opposed to. And so, in fact, they made no attempts to directly contact her to visit this child. The only attempts to ever have visited her, the child, were made through legal attempts. We don't have any problems allowing the visitations, Judge, but we do have some issues with the visitation that they're requesting from the court. The fact of the matter is that the dad lives with his mother, who's a chain smoker. The child's 6 months old with developing lungs, also a developing immune system. As you would know, Judge, a child that age has a developing immune system. It's not a fully developed immune system. In addition, the house is cat-ridden, so to speak. There's cats everywhere. I think there's 7 to 10 cats that live in the house. So there's concerns with the home environment wherein this child would be visiting because of cat feces, cat urine, cat just everything. And so we're concerned with the environment of the home, Judge. And obviously the court is very well aware that the standard is the best interest of the child. And my client has no objection to visitations. But since the child is breastfeeding, is 6 months old, we're asking that those visitations, Judge, logically be supervised and that they be in a place that is safe, in a safe environment. And I don't think those are unreasonable requests to have a 6-month-old child safe and visitation be supervised because of the nature of the relationship that does not exist or lack thereof. Now, in addition to that, Judge, we do have some concerns about the mental fitness of the petitioner. He's made violent threats to her and mentioned things that he would kill a baby if she was ever pregnant with another. She's seen him kick cats and things of that nature. So what we're asking, Judge, is before any of this takes place, that the court put in some safeguards, some reasonable safeguards for the child that we know where the kid is going to be visiting, that it's a safe environment, one, and I don't think that's unreasonable. Two, because of the smoking, because of the cats, because of all that. Two, that those visitations be supervised because there is no relationship, and because of the breastfeeding and those things of that nature. And three, that we make sure that as we progress towards actually giving him visitation, which is the goal, that's the goal of all parties, that he should actually have independent visitation at some point because he is the father, that we've established that he's mentally fit to be in possession of the child by himself. And I think all those things, nobody wants to deny him anything. In fact, my client is encourages it, and she wants somebody to a father figure in his life. We're just concerned about the environment, his mental fitness, and in addition to that, Judge, if you can encapsulate all that, we have a huge concern over the 19 deaths that occurred yesterday in Hidalgo County, the 453 and approximately 300 plus cases of new COVID every day. We think that giving somebody right now, we have no idea what his life is. We have no idea what his mother's life is. We have no idea what's going on. And so right now that child is in an extremely controlled environment because the child is 6 months old. And so we're concerned right now because, Judge, you're at home. We're all separated in our offices. And so because we don't know who, what, where, when with respect to this visitation, we also have a fear and concern for the general welfare of the child when it relates to COVID-19 and the worldwide pandemic that we're experiencing. And so we have proposed several orders that are motions that are set today, and those include a motion for the appointment of an attorney ad litem, and we believe that that's in the best interest of the child. We would like a mental examination. We think that's in the best interest of the child since we have concerns, they're real concerns, and there can be testimony if the court needs it, or we can verify these motions so that the court doesn't need to put on testimony, but that's the court's discretion. We also have a motion for the preparation of a social study, looking at the home, the home that the child will eventually go to, because the court needs to know what kind of home the court would be sending this child to for visitation. We also have the order that would appoint a third-party supervisor for visitation, making sure that whatever, when the court does and feels that it's safe for this child to be visited, or the visitation is to be exercised, that we have a third party that the court has assigned and says, this is who we want, I guess, supervising this visitation. So, Judge, we've got some very real concerns, not only from a global perspective, but from a local perspective, the home environment, the mental fitness, and COVID-19.
Your Honor, if I may, with all due respect, if the court remembers on June 17th, their client did not show up. Their client did not show up at all. She ignored that, and you made a temporary order based, and I could have asked for custody, Your Honor. I could have asked for full custody, and they didn't have a client to defend that. All they had was an attorney. Mr. Canales didn't show up. He sent somebody else. So
I'm going to object, Judge. That's argumentative.
With all due respect, Judge, with all due respect, I gave him his time. I didn't interrupt him. He did not file a motion.
But Judge, he's attacking me, Judge. He's attacking me personally, Judge, and I'm objecting to that.
I just said that he sent another attorney.
I sent somebody from my firm, Judge, and that's an attack.
Right.
My client,
and that's not what I'm saying.
You are saying that
his client didn't show up. She didn't care enough to show up to the temporary order.
That's
and
not
now
true,
she's
Judge.
trying to modify something, Your Honor, without filing a motion to modify. And she has to prove that a substantial material change has occurred in order to modify that temporary order. There's no modification. The court has no jurisdiction to modify without a motion to modify. That's one. As far as the home environment, Judge, Mr. O'Connor's father is an OBGYN. Miss O'Connor does not smoke inside the house. Miss O'Connor has been nothing but supportive. They took Miss Kayla in, gave her a home, and then she just up and left. Now, the reason that they haven't seen the child, Your Honor, was because they had been prevented from seeing the child. He was prevented from going to the hospital. And then there was a DNA that we confirmed that he is the father. He's been denied access since the child was born. You gave him temporary access, a temporary order. And that was on June 17th. So he's already missed several days. As far as him, a mental examination, Your Honor, they have no basis for a mental examination. First of all, they pled it under the wrong statute, which is Title II. It should be under Title V. It's not a divorce action. But even then, even just like technicality, Your Honor, there is no basis that he has sleep apnea. She understands and she knows that he got treated for that and it went away. And Your Honor, if you remember, you said supervised visitation with his mother. His mother would be there all the time, is what you said. So there is no issue about him falling asleep while driving or anything. Besides that, sleep apnea, which they're saying they're calling a mental issue, has already been way resolved. My clients are here to put that up into evidence. As far as the COVID-19, Your Honor, that is going on, but family law does not stop. Relationships, father and mother relationships do not stop. They continue. My client has been ultra safe, masks, they're very safe. They don't go out to the beach like you see on CNN, people jumping. They don't do any of that stuff. As far as, so yeah, the ad litem, I have no issues with that, Judge. You know that. That's not a problem for me. That's the only one I don't have an issue with. The ad litem can further talk to both parties and see, even if they want a social study, I'm not opposed to that. But what I am opposed to is that them trying to modify something without properly proving that the substantial material change has happened since the rendition of that order, which is Family Code 101. It's actually, I think, 156. That has not been pled for. And that is the issue that I have. They continue to deny visitation to my child. I'm sorry, to my client's child.
Your client's child.
And he's been trying to establish a relationship with his child since birth. And he was there before. They actually took care of her while she was pregnant, rent free. And then she just up and left when she found out she was pregnant and left them in the dark. So now my client is trying to has been trying to do the right thing since the beginning. But unfortunately, he hasn't been allowed. And Your Honor already gave him supervised visitation, everything properly ordered under the previous issue. If Miss Kayla was so concerned, she should have showed up last time, and she didn't. I could have asked for full custody, and they had no client at that time. They had no client to contest that. But you know what? My client is reasonable, Judge. He's reasonable.
Okay, now, besides the breastfeeding, is she drinking some kind of formula?
The child does not drink any kind of formula, Judge. My client's to my left. Let's see.
No formula whatsoever when you're 6 months old?
No, sir. I do power pumping, and I've worked very hard on supplying an oversupply.
Your Honor, I'm sorry. My client is not in the room. Not in the room.
So your client didn't show up. That's great.
No, my client is here. He's waiting in the waiting room. You all didn't show up last time.
All right. Let me see here.
Your Honor, I am going to need my client inside the room because he does. Yeah.
But wait a minute.
I didn't realize. I thought it was just the attorneys. I didn't realize that his client was right next to him.
Is he here? Is he available? Or?
Yes, John O'Connor. He should be there.
All right. Is he employed, Mr. O'Connor?
No, Your Honor. He just graduated school. He's about to get his certificate.
He's not online.
Okay.
Waiting.
Okay. And let me see here. Is Kayla, what's her last name?
Batesville, Judge.
Let me just call, Your Honor, just excuse me for 1 second. Let me just call him real quick. That way, make sure he's connecting. He should be in the waiting room.
Okay.
He's not in the waiting.
No, he's not in the waiting room. I'm looking here.
Hold on 1 second.
Okay. Who's that
Judge, he's made a lot of mentions of her not being here. That was my fault, Judge. We had problems because of COVID getting her in here.
Yeah, no, that's understood. But why?
And we won't make a big deal about him not being at this hearing.
Okay. I want Mando to hear this, what I'm gonna ask here. You see well, I'm waiting for Mando. Let me see here. Can you hear me, Mando?
Yes, Your Honor. He's He should be connecting right now. He should be in the waiting room already.
But I had my apartment. I turned in all the receipts. I turned in all the everything.
After 2 years, you can want to be around the mom because she was smoking.
Yeah, but she was smoking in front of me, so I would leave.
Okay, can you hear me, Mr. Garza, Mr. Canales? Can you all hear me now?
I can hear you clear, Judge.
Okay, the thing that concerns me more than anything else, we all know COVID, we all know parents want a visitation, we all know everything, is the
Your Honor,
breastfeeding.
can we go ahead and wait till he connects real quick?
Okay, well, it's just breastfeeding. I think chicken, I mean, that's the concern here, because if a baby only breastfeeds, then how are we gonna feed the baby when the baby's out of the mom's arms? I don't know whether a baby can do two things: breastfeed and also drink formula at the same time, or you can't mix it at both. It's either one or the other. And I believe a baby can breastfeed up to 2 years. I understand.
And Judge, her intention is to move the child over to formula, but by recommendation of her physicians and the pediatricians, breastfeeding augments and or advances the building of the child's immune system faster. And so they say it's the healthiest thing you can do, and it builds the child's immune system in 6 months.
Your Honor, if I may, can I just have my client see if we can connect so he can listen to all this discussion, please?
Okay, I don't see him in the living room. I don't see him connecting. I don't see him.
He hasn't.
Yeah, irony.
Yeah, he's doing it right now, Judge.
Okay, but we're talking about breastfeeding. I think. That's the new thing I find out here today. That concerns me is the breastfeeding.
In addition to that, Judge, just so you're aware, and we can for the courts, and we prefer to do it under seal, obviously, because it's extremely, I guess, personal. But we have provided to Mr. Guerra a log of, she keeps detailed notes for the pediatrician, and so we've actually provided those to Mr. Guerra, showing him the hour she feeds, when she feeds, and when she burps, everything, the whole thing. So they're clearly aware of what it is. I can show you, just as a matter of, I don't know if the court can see it, but it's a very detailed log about how things happen. And so and Judge, I'll reiterate, no one is opposed to him visitation. No one is. And I don't believe that the court has actually signed an order, as Mr. Guerra's.
Judge, the court has not signed an order, but it was an oral order. And in family law, Judge, whether there's a signed order or not, attorneys are supposed to respect the judge's order.
Judge,
Okay,
Judge, let me, I'd have to respond.
I think he's coming in already. Is he in already?
Yeah, I believe he's there with his mom also.
Mother. Okay.
Or, yeah.
Okay, can they hear me now? They need to unmute, right? Can you hear me?
I can.
All right, good morning.
Good morning. John's right next to me, but his laptop's going slowly.
Yeah,
Okay,
I'm very sorry.
all right.
They have to be in one, otherwise we're gonna have echo.
Oh, I understand we can only be on one.
If they have to open, we're gonna have echo.
If you have two open ones, we're gonna have some echo.
They could just use that one.
Yeah, just use
Oh,
one.
okay. This. I'm gonna
Yeah,
hand
we-
it to John.
Okay, we're gonna have, yeah, that's right, we're gonna have an echo here. Okay, all
Okay.
right. No, the concern I heard so far this morning is the allegations of the breastfeeding and breastfeeding only.
Okay.
Is that
What?
Mr.
Can you
Canales mentioned?
clarify that, please?
Mr. Canales mentioned a log, all that is here is just breastfeeding. I asked, can there be formula that can baby take? Because obviously the baby's going to be going to the father's house. How are we going to feed him?
I mean, this is the first time I'm hearing her bringing that up as a concern as far as
That was not-
breastfeeding. I mean,
It was not pled at all, Your Honor. So the whole breastfeeding was kind of thrown in there at the end, just like,
Well-
they've been doing. Other issues when my client was not here
Okay.
was that the mom's a chain smoker. Miss O'Connor's a chain smoker. She smokes inside the house. Apparently their house is
Okay,
unfit.
hold on just a minute, Mr. Gunn. Hold on just a minute.
I'm just trying to catch them up, Judge. I'm sorry.
If they would have been here on time, Judge, it wouldn't have to catch anybody up. but-
If your client would have shown up last time, this would have been different, right?
I'd ask counsel to
He
address
didn't-
the court, not me personally. Be a little more
And Judge,
professional.
she ignored all this before. If this was such a concern, she would have showed up last time, and she didn't. She didn't show up. That's not the attorney's fault. That's the client's fault.
Judge, and in fact, I already explained to the court because of the what's going on. It was our fault. It was my office's fault. But since Mr. Garza does not practice in my firm and he's not in my office, he doesn't know the situation that we explained to the court already.
Well,
But he
I'm
can make all the
saying, I'm
allegations
saying
he
it
wants.
wasn't. If she was if she was interested in this case, Judge, really concerned, then she would have shown up last time. There is no motion to modify, like I've told you, Your Honor. The court has
There's
no
also not a
jurisdiction to
signed.
change
There's
it.
also not a signed order, Judge. And
Doesn't
so
have
there's
to be a
no-
signed order.
There,
Doesn't have to be a signed
clearly,
order.
Mr.
Judge.
Mr. Guerra doesn't understand the concept of a signed order, Your Honor. If you have a signed order, I cannot modify something I cannot
So,
modify
Judge,
something that's never even been
Okay.
signed, Judge. And
So
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 come
Judge,
back on.
what he's trying to tell me is that if there's an oral order issued, I don't have to follow it. Judge's
Look,
oral
guys.
order doesn't really mean anything.
Guys,
And
we're
it's
living
an order. It's not going to change.
in a pandemic period, okay? I mean, it's not World War III or World War I. It's an invisible enemy, even worse. This is the time we need more counselors and attorneys. Your certificate on the wall will say attorney and counselor. I've seen so many lawyers here and no counselors. And this is the time when we need counselors. I mean, counseling from lawyer to client. I need counseling. Lawyers need counseling. This is a very critical period. Fighting and who showed up and who didn't and who came, and that's not going to do anything. We have the COVID to deal with. And in light of that, how can we have the baby? How can dad see the baby? Dad's entitled to the baby here. Maybe supervise. Maybe that the mom can pump milk and put it in storage, and then with that can be for a period of 4 6 hours or whatever. But dad's got to see the baby and the grandma also. I mean, we're trying to nourish here some more relationship between the baby and anybody else, parents and grandparents. But right now, this is the time we need more counselors than attorneys. And there's too much bickering going on here. That's not counseling. And
Yeah.
we need it.
I realize that, Judge, and yes, if we could solve this breastfeeding, if it's in fact true, then yeah, if we could solve that. My client has been wanting to see the child since birth, and he was denied that access. Imagine what that would feel like, Your Honor. That
No,
it's inexcususable.
Judge,
No.
that's Judge, and I don't mean to, and I agree with the court. I agree with the court. I want to find a solution. I'm just tired of the
Right.
inaccuracies being misrepresented to the court. But look, we're here to find a solution, Judge.
Can we quickly get a mediator to look into this, like tomorrow, next day?
We actually filed it. We have filed a motion for a mediation.
Judge, yeah, they did not comply with the order. You actually ordered 30 days, mediate. We sent them requests. They've ignored them. We sent them
Right.
requests to sign our temporary order. They ignored them. That's
No,
that's going on.
yeah, but I think the breastfeeding here is so important and so, I mean, if you're gonna ignore some order, I think this is the time because the baby cannot eat nothing but the breastfeeding. Then we didn't consider that when we did the order last time, whether she was absent or
Because
not.
because she
I
didn't
mean,
show up. But
my concern is this. I mean, can we do some pumping? Can we do something else? That's why I think you need to get a mediator that can look into it and today, tomorrow, and study a schedule or something for visitation and consider the pumping. And then if there's any formula, maybe doctors won't recommend it now, or maybe there is some substitute. I don't know. We have a 6-month
I
baby here, and it's a serious thing.
I have tried, Judge. I have tried to comply with your order, but I've been prevented. So I've been wanting to go to mediation, but my client needs to see the child, Judge. I mean, what if
Okay.
mediation is, far in advance? I mean,
Judge, we'll agree to
my
mediate.
my client
We'll
We'll,
my
we'll,
client has been
we'll
waiting. I
agree.
mean, more
no, 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 we're gonna
waiting.
mediate. We're gonna mediate this week. What's the day? Wednesday? Yeah,
Yes.
between now and Friday, let's get a mediator.
Agreed, Judge.
I'll appoint somebody right away, or
I
I don't
I
think you
have
guys are gonna.
I have Friday already booked for mediation on another family case.
Uh-huh.
Thursday, I wouldn't be able to do it Thursday either. It would have to probably be,
Monday.
let me see if I can, let me see what I
Judge, if
schedule
you want
Monday.
to if you want to appoint somebody today, we'll mediate it this afternoon, Your Honor.
Guys, this is
We're
serious
ready.
because
We're ready to help the court resolve this.
yeah, I have I'm trying to see if I can get somebody this afternoon.
There's an attorney that's or a mediator that's been real, I guess, helpful.
Flexible.
Jane, her name is Chin, but that's
I'll be able to do it on Monday, Judge. I do have free on Monday.
How about this afternoon? With Jane Sheen,
Jane
is that her?
Shin. She's
Is that her?
Jane Shin.
Yeah,
I heard of her.
Your Honor, I would suggest doing it with like J.R. Garza, Evelia Signs, if they're available. We actually had reached out to them to get dates and stuff already.
What about Priscilla Hassel?
I've mediated with Priscilla Hassel before.
She's not an attorney, right? She's not an attorney.
She's not an attorney, no, Judge.
No, she's not an attorney. I've heard of her. Mr.
I've
Canales?
mediated cases with her.
Judge, whoever the court appoints,
may be-
we're ready to
she
help
may-
you resolve the matter, Judge. I don't want to sit here and bicker with Mr. Guerra about who showed up and who didn't. You're correct.
No.
Let's solve it.
Maybe she may be available this afternoon, and I think because Mr. O'Connor and Grandma and Grandpa and everybody's grandparents ought to also start nurturing a relationship with the baby.
Agreed.
Problem is, Judge, I'm not available this afternoon. Monday would be the only time that I am available. And they're laughing, Judge. They didn't even show up to this case. This case has become more contentious than it has to be.
Again,
all we're
Judge,
trying
he's
to do,
bickering instead of resolving.
all we're
Judge.
trying to have to do is resolve this. But they're taking it as a joke. This is not a joke.
How about tomorrow afternoon,
this
Mr.
is his
Garza,
daughter.
or the morning? Tomorrow morning or afternoon?
Yeah, tomorrow I am booked up also, Judge. Monday would be
And Friday?
This afternoon.
Yeah, Friday I already have a mediation set with Evelia Signs.
We'll just make ourselves available when Mr. Guerra thinks it's fitting, Judge.
I've already told Mr. Canales I'm available on Monday. Let's do it on Monday.
Well, you know what? The who do we get? Priscilla Hassel?
At 2 o'clock.
She says she's available 2 o'clock today.
Ready, Judge.
Jane can do
2 o'clock today.
Ms. Shin said she's available this afternoon as well.
I don't mind doing it today, but it's gonna have to be a little bit later than
Okay.
then I do have a hearing at 1:30. It should be at maybe 2:30. I would probably be available maybe around 4. 4? I'm fine.
Fine,
I
4
can do it
o'clock.
today.
4 o'clock. Let's do it, guys.
Perfect,
It's-
Your Honor.
It's critical because I mean, what threw me off today was breastfeeding. I mean, that just threw me off.
He's
And I
never
didn't
mentioned it
expect
before,
that.
Judge.
I didn't expect
Never
that,
mentioned
and
it
I think
before.
we need to work with it very seriously here. And but
I
consider
don't
all those
think-
points I brought up this morning, and go over with the mediator. But 4 o'clock will do.
Yeah, I don't expect any. I really don't expect an agreement, Your Honor. So we do need another date so we can have a full-blown hearing.
That's a great attitude to go into it,
No.
Judge.
Well, I'm sorry, Judge, but they've been delaying this case from the beginning, and my clients are frustrated. They're frustrated because she can't see her grandchild, and he can't see his daughter. My
Judge, why don't we, Judge?
frustration is coming from my clients. My
Judge,
clients
if Mr. Guerra
frustrated.
would take a break for a minute, we can agree that he can see the child today in Harlingen at Peter Piper Pizza, wherever they can agree, so they can see the child today. So you can see that we want to work with the court to move this forward. We can agree
Okay.
right now with the court to have a controlled
And
visitation
then,
today.
How about they just bring
Can-
the child to
can I
my
speak?
client's house? Yes, yes. Good.
Oh.
I'm sorry, Grandma?
In, yes,
Yes,
in
Grandma.
light of COVID,
Yeah.
I don't know if he is serious, but Peter Piper Pizza sounds horrible to me.
Yeah.
Horrible.
But
No.
our point
Your
is,
Honor,
Judge, we want them
she's
to
I
see
mean,
the
it
child.
sounds,
Your Honor, she's lived
It
with my
sounds-
clients. My clients have taken care of her prior to us. She was pregnant and everything.
Judge, that's not true.
Why
She never lived
can't,
there.
why can't, yes, she did. She lived there.
No,
Why,
you know
why
what?
can't she go to their house?
Judge, if you
And
could
we'll do it
hear,
like that.
if you're listening, Judge, the court's listening, our side is telling you we want to work it out. Their side is saying it's not
They
happening.
haven't been judged. I've
Look,
sent text messages,
I
I've
think
sent
that
emails,
because
they haven't.
of COVID, we can't have too many people around. You know what I'm saying? It's
That's
got to
right.
be limited to very, very, very few people.
To a
here.
residence.
Hopefully a residence, yes. I'm thinking even Grandma's house. I mean, she's not going to smoke inside the house.
And so,
Nobody
and
does.
so
I mean,
Connor does, that's
and Mr.
completely
Connor's there.
ridiculous.
Even today for two or
Yeah,
3
she
hours
does.
today, and in mediation, if it doesn't happen today, then Monday we can mediate on Monday.
We would still ask for the mediation to happen this afternoon, Judge. He did say he's available after 4 o'clock. We want it to happen.
I'm available.
Okay.
Let's
Okay.
do it.
4 o'clock. It'll be 4 o'clock with Priscilla Hustle. And then
We'll send them all the information
through email, we're gonna send the
for
information.
information.
We're gonna send her the information then.
And then
Okay. And with all the attorneys, the information. You know where her office is? I think it's by,
But she doesn't by Zoom, Judge?
yeah, it'll be Zoom. It'll be Zoom.
mediation
It'll be Zoom.
through
That's
Zoom?
right. That's right.
Yes,
That's
yes,
right.
Your
I
Honor.
keep forgetting about the COVID. I keep forgetting about
Yeah,
the COVID.
yes, Your Honor.
Okay. Let's do that. And then 4 o'clock. Okay?
Yes, Your Honor.
4 o'clock. Do we do a status hearing on can we do one like early, like Monday or something in case? Can we do one on Monday? You want to hear this thing? You want to see what happened?
That's fine, Judge.
at 10.
We-
Then at that time, I'll have to just put the hammer on it if you guys don't agree on something.
We're in agreement with the court. We want to resolve it as well.
All right, let me give you a time for Monday.
Yes, Your Honor.
Give it a chance to mediate and considering all the points we just discussed here. And then we'll set it for status on Monday to see what happened. Right now, I'm checking my schedule right now for Monday.
Status
Everybody
on
available
Monday,
on
Judge,
Monday?
or do all the motions get carried over?
But they'll be carried over.
Okay,
Judge, it'll be
11
myself. It'll be myself or one of the people one of the associates that works at my firm.
Can we do 11 o'clock on Monday?
That's fine.
yes, Your
Status?
Honor.
Status, 11 o'clock on Monday, and then all the motions get carried over. Okay, Ms. Hasso is gonna be notifying everybody right now.
Yes, Your Honor.
All their information.
Yeah, we'll set the information to everybody here.
Yes.
Thank
Is
you,
that it
Judge.
for right now?
That's it.
All right, thank you all so much, guys. Please try to work it out.
thank you.
Remember, we need
Thank you, Judge.
counselors. Counselors, not lawyers.
Thank you.
Thank you, Judge. May I be excused, Judge?
You may be